All right, well, we're going to go ahead and get started. I'm sure people are going to still filter into the room, but we thought it was a good idea to put out our annual pool reminders. And some folks have said, well, why don't you do this in the fall? Because a lot of contracts are entered into at that point. And that's not a bad idea. Well, we've made a note of that. But also, there's still a lot of people that don't have contracts in place for the upcoming pool season, which is kind of last minute. But even if you had to put one into place, it's time to learn a little bit more about some options that are available and some things to consider as you move into the following year's pool season. So I'm Mark Markel. I'm joined by Eric Tonsul. Eric is a shareholder here in the Houston market, and I kind of travel the state. I'm the wandering shareholder, if you will. And so you're liable to see me in any one of the offices around the state. I look forward to seeing you all back in person as things do get back in person from the COVID storm. All right, we've done as much research as we can. Some of the things we're going to talk to you about are our opinions, and when that's the case, we'll tell you so. Some are as a result of actual true law, and those are things that are just not up for debate at this point. But some of the issues regarding swimming pools really make a difference as to liability of your association. So if you have questions along the way, I'd ask you to please type them into the chat box feature, which should be at the bottom of your screen. And we'll get to as many of them as we can, either throughout the presentation or at the end of the presentation. Eric is going to start first, and he's going to talk to us a little bit about lingering concerns from COVID, as well as the lessons that we learned in preparing for the upcoming pool season. And then I'm going to take it from there to talk about the exciting topics of indemnity and insurance. So Eric, take her away.
All right, thanks, Mark. So first of all, thank you guys for joining us today. We're going to rip through this and get this done in about an hour. But first, we're going to talk about the lessons that we learned from COVID. It's been a crazy 2 years, as we can all attest to. And, the guidelines have changed. The CDC guidance has changed, at the beginning, almost monthly or even weekly. And now we've kind of tapered off. And so, as everybody knows, we've had to adopt and adjust managers and attorneys alike and board members, of course, as to what we're going to do with the pools. And even as we sit here today, Mark, in March of 2022, we still have some unknown conditions as far as what to do with the pool. So we're going to talk about that a little bit as far as what do we do in 2022 versus what we did in 2020. So the current guidance from the CDC is you don't have to wear masks in outdoor settings if you're able to maintain your social distancing, which we've all come to know and love that term for the past 2 years. But if you're in an area with a high number of COVID cases, depending on your location, wearing masks is advisable if you're going to be in close contact with others. Don't wear a mask in a pool unless it's like a scuba mask or something like that. But wearing a mask in a pool is not a good idea. I think we all know that by now.
So Eric, I've looked at the formulas in preparation for today, and I saw that Galveston County and Fort Bend County were in that elevated number, but Harris County and Montgomery County were not. Is this something that managers need to keep aware of, or is it something that the population should be aware of and just take care of themselves?
I think that managers should be aware of it, but ultimately it's on the individuals to take care of themselves, Mark. It's, as we know, COVID is a very polarizing topic. Some people think it doesn't exist, while other individuals are acting like they were in 2020. So at the end of the day, I think it's again, being aware of it from a managerial standpoint is important, but ultimately it's a decision for each individual to make for themselves and their families.
All right, and are you going to have a chance this morning or this afternoon, whenever we get to it, to talk to people about how to handle the complaints from the homeowner when they say, I can't believe you're doing this, or I can't believe you're not doing this?
Yeah, we can get into that.
I really wish you would, because I think that that's going to be some of the issue that the individual management team members are going to be facing because of this rift in the country. Some people are going to think we're too open. Some people are going to think we're way too closed.
Correct. Correct. And to that point, you know, if an association decides not to open their pool this coming pool season,
wow,
there's going to be quite the pushback.
I think tar and feather, Eric.
There was already a significant amount of pushback last year. Yep. And so 2022, and especially with Biden's, statement of masks and COVID and that kind of thing. If you don't open your pool, you're going to get a significant amount of pushback. But if you do open your pool, that doesn't mean that we should go Wild West and just go back to pre-COVID days. So a lot of the associations that we represent, we prepared waivers and signage for the associations dealing with COVID. But if you do open, we definitely recommend that there's an enhanced disinfection process, because a lot of the individuals are not going to be as strict with their COVID protocol, for lack of a better expression. Mm-hmm. So definitely, if you do decide to open your pool, make sure you have a disinfection process in place, that you know what you're going to do. You get with your pool contractor, if you've contracted with a pool vendor, to make sure that you have that process set up, ready to go, that the cleaning continues, and that, where I get to this in a minute as far as the waivers go. But as far as occupancy limits, there's no guidance on that like there used to be. Yep. That's kind of gone by the wayside. So if you feel the need to employ or put out an occupancy limit situation for your employee, again, you're probably gonna get a lot of pushback from that. So keep that in mind. Furniture and pool toys, again, case by case basis as far as how the association wants to handle that. Obviously, if you do have your pool furniture out and toys, make sure that those are subject to the disinfection process that we just talked about.
And if y'all are using a pool vendor, the reason why we use a pool vendor is either for safety or shifting of risk, or both. And when I like shifting of risk, I would go to the pool vendor and say, what do you recommend as to enhanced disinfecting? And are they cleaning the bathrooms as well? And, at first we were all concerned that if you touched something, you would have COVID in a half an hour. And then the guidance from CDC changed to where there's not a whole lot of life to the virus on certain surfaces, and different as to soft and hard surfaces. It wouldn't hurt my feelings if we had no pool toys, but it would also not hurt them if we had pool toys. You just have to do whatever you're going to do and do it consistently. And make sure that your vendor, your lifeguard operators, if you have them, are also in agreement with your plan.
Agreed. So again, at the end of the day, it's a board decision whether to open or not. But the board members that are maybe on this call need to be cognizant of the pushback that you're going to receive if you don't open your pool, which is what we talked about earlier.
Right. Now, from our standpoint, from a law firm, we are not advising anybody to keep their facilities closed unless they have insufficient money to maintain the facilities in a way that's safe. Correct. All right.
So steps for preparing for opening, get with your legal counsel. As I mentioned earlier, we drafted a lot of waivers and signage at the beginning of all this. It's not a bad idea to have those waivers and signage reviewed by your legal counsel to make sure that they're up to date and address any issues that may be different in 2022 than they were in 2020. Make sure that you have your insurance policies reviewed. It's very important that, in some policies now, Mark, you have pandemic provisions, that kind of thing. And if you're operating on a contract that was executed 3-4 years ago, whatever, it may not have anything in there. So you might want to look at that, your insurance policy, see if that's applicable. Again, your disinfection process. And then a big thing that we're going to talk about a little bit later in this presentation is whether or not to go with a guarded pool or a SAYOR pool. SAYOR, for those that don't know, is an acronym for swim at your own risk. And so we will dive into that, no pun intended, heavily later on. So speaking of SAYOR pools, These are pools that don't have lifeguards or pool monitors. So now this is not a one size fits all. You say, hey, that's a great idea. We're not going to spend money on lifeguards. Well, that may not apply in your municipality because in some areas you're required to have lifeguards by law. So again, what's something you need to look into. And then you also may have issues with non-lifeguarded staff. You don't have anybody there kind of policing the pool area to take care of issues that may arise, maybe disagreements or squabbles or whatever you want to call it at the pool. So those are some kind of the downfalls of a SAYOR pool. Again, we'll get into more of those later on in the presentation. But
all right, as we introduce the topic of SAYOR, I think it's important to note that not too many years ago, we would say absolutely positively have a lifeguard because it's beneficial to transfer of risk. And I still kind of believe that myself, but at the same time, I've lost a little faith in it. I've lost a little faith in it because of who comes and is our lifeguard, you know? And the fact that there's a 15-year-old sitting on a stand, does that mean that the parent or caretaker of the child is less likely to observe the child in the pool thinking that somebody else is watching?
Yeah.
And I think that we have to do something, even if we do lifeguards versus SAYOR, to point the individuals to, yeah, the guy in the chair is a lifeguard and he's hopefully lifeguard trained by Red Cross, but the parent also has to keep eye on the pool, that this is a team effort.
Right.
We've had some drownings over the past few years around the state, and you can't expect one or two lifeguards to be able to keep track of everything going on. I think it's everyone's responsibility to take care of that. And we also used to say lifeguards are better because of the shifting of the risk, but if you'll stand by and just keep that in mind, the shifting of the risk is no longer as good as it used to be. That shifting of the risk has really gone downhill considerably. So the benefit has got to be the lifeguard themselves as to safety. So
correct. And that's something that the associations can discuss with their pool vendor if they do go with a pool vendor, is having mature lifeguards versus having a 14-year-old.
But Eric, that's going to cost more money.
It more than likely will, or you might even get a response from a pool vendor says we don't have access to mature lifeguards. But again, you can't get what you don't ask for, and so definitely explore that option if you do go with if you do have a pool vendor that's providing guarding for your pools, because as Mark said, I believe 14 years old is somebody can be a lifeguard at 14, and putting the lives of numerous individuals in the hands of a 14-year-old is a pretty scary proposition.
And it's questionable whether I'd allow a 14-year-old to wash my car, not watch my children. So that's something that we really need to be cognizant of. And keep in mind, too, that not all pools can be SAYOR pools. And Eric alluded to this, but the pools that have the toys in them, the fountain slides, rock walls, cannons, and ones that are jumbos are required to have lifeguards. So don't assume that all pools can be a SAYOR pool. There are legal requirements.
Correct. So talking about the pluses and minuses of the SAYOR pools, again, SAYOR pool, there's fewer expenses on the association, obviously, because you're not paying the pool vendor to provide lifeguards. They're still going to obviously, or most likely, maintain the pool, the chemical composition of the pool and issues along those lines, and maybe the disinfection process. But again, it's more than likely going to be cheaper than having lifeguards. You can also mix and match if you want to do that. If you have multiple pools, you might have one that's guarded and one that isn't. Again, cost reduction on your end. But the minuses, potential liability. Without anybody minding the store, so to speak, and if we have parents or guardians who are at the pool and they're playing on their phones or iPads and not doing a good job of looking out for their kids, obviously that there's a potential there for an increase in an incident to occur at the pool. Also, as Mark alluded to earlier, there's no risk transfer. In other words, we'll be talking about MSAs later on in this presentation, which is an acronym for Master Service Agreement. And that's where we can shift that risk to the pool vendor rather than the association. But if you obviously don't have a pool vendor, then it's the association's insurance that's going to be the first bite of the apple if an incident were to occur. So those are some things to keep in mind with the SAYOR pools.
All right, so let's move on to the next issue. What do you think? Benefits? No benefits?
Benefits of the SAYOR pool?
Yeah, I mean, is the only real benefit is the cost savings?
Well, that's the most important benefit, I would say, Mark. But let me put it back on you. What do you think is another benefit?
I don't know. I mean, this is a really serious topic and a hard topic. And I would hope that there'd be some statistics, but I searched for statistics on drownings in guarded versus unguarded pools, and I was unable to find anything. And, if you ask your pool vendor about SAYOR pools, they're going to not recommend them. Okay. So there's not a whole lot out there for us to go ahead and take a look at. I do agree with some of the comments you have on this slide as to things you would have to do to advise people of it. But not many people will read like a website that says, hey, our pools are no longer guarded, or these particular pools in our neighborhood are no longer guarded. And then I want you to compound that with the fair housing related issues. So now we have a pool that's not guarded, and the federal government is telling us that we can't discriminate against children.
Correct.
All right. So now we have a pool that has a self-latching gate, which hopefully has some kind of a lock device that a card or a number will open. Nobody there, 14-year-old, 12-year-old comes in, goes for a swim. I still think that it's a pretty good idea to consider all those things and the makeup of your community when you're trying to decide whether there's nobody there. Some of the things I've heard is, well, we're going to get a pool concierge or a pool attendant, okay? For those of you who are doing that, I only have you to ask yourself one question. The pool attendant is there, and they make sure that everyone's a neighborhood person when they come in. They check their card or something. And the pool attendant notices somebody flailing around in the pool drowning. Do they continue to look at their cell phone, or do they bolt into action and do anything? And if they're going to do something, then they're a lifeguard. I don't care whether they're trained or not. You're putting yourself at a risk because you're having a monitor there, and the monitor would be relied upon. Unless you had a big sign on them, maybe a shirt that said, I'm a pool attendant. If you drown, I will not respond. Okay. And I don't think that would be really good in the neighborhood. I think that would be a bad act.
I agree.
All right. So anything else? Any other exposure things you want to talk about?
Well, you bring up a good point, Mark. Is with the SAYOR pool, there is actually a potential for less liability.
Yep.
Because if you put it out there to the masses, this pool is not guarded. There's no, you're swimming at your own risk. You're responsible for looking after your kids, whatever the situation may be. You might actually find yourself in a more advantageous position from a liability standpoint versus if the pool were guarded, believe it or not. And a lot of that has to do, quite frankly, with insurance requirements and that kind of thing that Mark will talk about later on in this presentation. So yeah, there's obviously a lot of variables. We're not here to give you guys a black and white answer, go SAYOR or don't go SAYOR. That's not the purpose of today's presentation. The purpose of this portion of the presentation is just to give you guys pluses and minuses and some things to consider when your boards are making a decision as to how they're going to operate in 2022 and going forward.
And if you haven't ever had this discussion at a board level, this is a great executive session topic, and include your attorneys. And it doesn't matter if it's our firm, someone else, or include your attorneys, because your attorneys should give you some opinions based upon your specific pools and your specific situations.
All right, so let's get into the vendor contracts. Obviously, pool vendor contracts. Well, first of all, the new law that came out in September of last year requires associations to solicit multiple bids when the amount of the bid for services is over $50,000. Your pool vendor is most likely going to be more than $50,000, depending on
How many pools?
how many pools, yeah, that kind of
How
thing.
many lifeguards?
So keep that in mind, that law is in effect. So if you're soliciting bids for your pool contractor and it's going to be over 50 grand, you need to solicit multiple bids. And that's not to say you don't have to go with the cheapest bid. That's not what the law says. It just says you have to solicit multiple bids. So that is the deal there with the new law. Keep in mind that, and Mark alluded to this earlier, that the insurance that's available to pool vendors seems to be decreasing.
Yeah, and we're going to go through that in detail.
Okay, so I won't steal the thunder on that.
Thank you.
We recommend using an RFP and an MSA when going through the vendor process. RFP really saves a lot of time on the front end, because if a vendor isn't going to come close to meeting the requirements that the association has for a particular vendor, then you won't waste your time or their time reviewing them, having them put the proposal together and then having us review. So but the MSA is extremely important. We'll talk about that a little bit later. As I keep saying alluded, I'm sorry. As I mentioned earlier, pandemic clauses are paying contracts. We need to look at that. And then what if a clause for a government order forcing an amenity to close? That's kind of akin to a force majeure in a way, Mark. And so what happens if, let's heaven forbid, but COVID ramps up to times 100 and the government forces us to shut down our pools? Again, like a force majeure clause in a contract, you may want to have some provisions within that contract that address if that issue does arise.
Right, and you want to make sure that those provisions are mutually dependent provisions, not mutually independent provisions. And what do I mean by this? I mean that if we are told that we should shut our pool, it should say, then we don't have to pay for the service. The contracts in the past required payment, notwithstanding the fact that they couldn't open and operate. So it's a difference between a dependent and independent contract costs. And so always try to have operations tied to payment.
All right, so the vendor questionnaire, it's a very useful tool. Find out the financial condition of your vendor. From an insurance standpoint, especially, as we said, insurance is going down. A lot of pool vendors are saying they can't get, for example, excess or umbrella coverage, or it just cost prohibitive for them to get excess or umbrella coverage. Now, to be fair, that is not across the board the truth. As far as, I know one vendor that has $10 million in excess liability coverage.
Right.
And matter of fact, I just reviewed an MSA yesterday where the pool vendor had $5 million in excess coverage. Right. So it does exist. Now,
but what if I don't like that contractor?
Yeah, well,
I like the contractor that only has $5 worth of insurance.
Yeah, and a lot of decisions are made along that line of thinking, Mark. And as a board, you need to be cognizant and aware. At the end of the day, you're looking out for the well-being of not only the owners, but you also have a duty and responsibility as far as from an association standpoint. What is in the best interest of the association? And having $5 million in insurance versus $1 in insurance it's a substantial thing, or no insurance.
So the purpose of the questionnaire is you put out an RFP that says we want you to have limits of insurance as follows, and we lay it out. And then it says, if you do not have that, let us know what insurance you have available and answer the following questions. Because we want to know how many drownings have they had on their watch in the last 3 years? And what type of insurance policies did they have and the amount of coverage? Because we also want to find out if they're going to indemnify us, what are they going to indemnify us with?
Yeah.
Most contractors don't maintain a whole lot of liquidity. They need your payment to pay their employees and their rent. And so if they're judgment proof, the indemnity could be super strong, but it may not be worth anything.
Exactly. All right, so on the MSA, I'm not going to get too deep into this, but again, this is a document that we draft, and we typically attach the vendor agreement, the contractor proposal that you get from your pool vendor as Exhibit A to the MSA. In the event of a conflict between the two documents, the MSA controls, and that's the contractual language that we include in the MSA. And that's important because a lot of the contracts from vendors are drafted very heavily handed in favor of the contractor versus or the vendor rather than the association. So we kind of flip the script with our MSA. And again, this is the whole risk transfer and indemnification, all these words that we're using throughout this presentation. That's how we accomplish this, through the MSA. The MSA also talks about insurance requirements. And that's, as Mark mentioned earlier, on the RFP and the vendor questionnaire, we already set those out, but we include it because we make them contractually obligated to follow that insurance. But it's very important, Mark, and you're going to get this here in a little bit. A certificate of insurance is very important. Certificate of insurance shows what policies the vendor has and the policy limits, and in addition to a lot of other information. But that is, just that COI is just a piece of paper. That's all it is. And so, you really got to have the contractual document in place to take care of and insulate the association in the event something occurs.
Right. In fact, this MSA should be attached, which is a master services agreement. It should be attached to the request for the proposal, to the RFP, so that the vendor knows what the terms and conditions are that you're seeking. And insurance basically is out there if there's a requirement for it to fund. So if you have an insurance requirement in a contract, then there's a contractual obligation the insurance will fund. Without the contractual obligation, you can have all the insurance in the world and it has no obligation to fund.
Correct.
And so we want to make sure that all of the balls line up in the court to where if there is a claim, there's not a problem. So let's get into the exciting topic of certificates of insurance. I've had this one cut up a little bit so that we can take a look at it and see kind of how it puts itself together. And what's really, really important here is that the information be correct. I can't tell you how many of these COIs I've reviewed over the last 10 years, but it's been a lot. And in the area where it says insured, a lot of times it says the management company, not the association. Sometimes it says the association, but doesn't put the name right. It says ABC HOA as opposed to ABC Community Association. Wrong name, wrong liability, potentially no coverage because the insurance company said, well, you gave us the wrong information. Well, this is going to have the pool company's name in this blank. And the pool company may not operate under ABC Pool Company. They may be ABC Recreational Services, Inc. doing business as something. We want to make sure that their legal name that they're buying the insurance for matches the name that you're entering into a contract with, so there's no questions when a claim arises that take care of it. All right? Very, very, very important. On the right-hand side, we have a list. We have 4 different insurance companies, all providing different levels of insurance. And we want to make sure that those insurance companies are AM Best rated to match what we've asked them for, and that those companies are admitted carriers. That means that they're licensed to do business in the state of Texas as an admitted carrier versus an excess or surplus lines carrier. And the difference between the two is that if an admitted carrier goes out of business or becomes insolvent, the state of Texas has a guarantee fund to fund the policy. If it's an excess or surplus lines carrier, then you have this piece of paper that you can throw at people who sue you because that's all you have. You have no insurance. All right, let me move on to the next midsection of the same page. And this is where it gets all kind of funky. If you look up in the top corner where it says commercial general liability, it says this is an occurrence policy. That means that you have insurance for each occurrence. If it would have said claims made, then you have to make a claim and report a claim during the policy period, or you have no insurance. So occurrence is what you truly want. And then deductible, sometimes it'll use the word retention, but it's the same thing, which means that this vendor has to pay the first $25,000 of liability claims. This is not common, but this is something that we are seeing more of. Right below it, you see where it says general aggregate. That's an aggregate for the policy and the project. That means that the total amount, which we'll look over to the right, which says general aggregate of $2 million, is the total amount of insurance they have available for your project and for every project they work on for general liability. And if you look at the bottom on the right of that top, it says all project aggregate, $5 million. So these are things that are a little bit in conflict with each other, but you could read this to mean that they'll pay up to $1 million for each occurrence and a total of $5 million across all lines. Now we'll go down to the next section, which is auto insurance. And we're going to skip that because pool vendors really don't have too much auto insurance problem unless their company vehicle hits somebody. But then we'll go down to the next where it's umbrella and excess. And an umbrella sits over policies and excess extends from them, basically the same. Also an occurrence policy. And this one here has a $2 million aggregate. That's a total aggregate for all claims involving excess. So if we wanted to decide how much insurance would be available to our community potentially for a claim for one event, you have a $1 million cap on liability and a $2 million cap on the excess policy, as long as it hadn't been used before it got to our claim. And that's the big question. Did it get used before it came to us? If it did, then we only have $1 million worth of liability. All right, and then underneath there, you have workers' compensation. As long as it's a statutory amount, $1 million is going to be plenty, not a problem. And then you have a bunch of endorsements, okay? And let's look at them real quick. It's a blanket additional insured form. That way there, the association is insured as the insured is insured. The next is that this insurance is primary and non-contributory. That means if there's a claim, the insurance for the association is secondary. The next is a waiver of subrogation. This means that even if the association was negligent, the pool vendor's policy would pay first. And those are critically important. Those are all required inside of the general MSA that we recommend to the association. I'm going to point out one thing to you here. Just because you're primary and non-contributory, just because you're waiver subrogation, and just because you're an additional insured, when the insurance company pays out the total amount it needs to pay out, they say, hasta la vista. And they go on down the road and they're no longer going to defend the association. So we want to make sure that we're not losing the ability for the transfer of risk, which was one of the main reasons why we did this. I want you to keep in mind that on that general liability policy of $1 million, that's a total amount, including costs of defense and expenses. So if the attorney's fees for a drowning case are $100,000, then that primary limit only has $900 left. All right, so we want to be careful on that. Let's move on to the next little thing. And this is the certificates holders position. And this is where the association name needs to be absolutely correct. If the association has agreed to indemnify management in its contract with management, put management in here too, because contractually you're going to be obligated to indemnify them if a harm occurs, and you might as well transfer that risk at the same time, and you want to include that in your master service agreement. This is a blow up of what I showed you before, and the reason why I put this on here is for the asterisk. And that says to us that the blanket additional insured and non-contributory and subrogation waiver only apply when there's a written contract signed by both parties prior to the loss. That's why your contract is critically important. For those of you who are still signing the pool vendor's proposal for lifeguard service, they could have all the insurance in the world. It will never defend the association in the claim. So that's what we want to be careful about. So let's just understand some terminology because this is where we get into some considerations. We have aggregate. Aggregate means total insurance available. But then you have to apply the qualifiers. It's an aggregate per association. Well, what if your association has 6 swimming pools? You still have an aggregate per association, then that's an aggregate for the total. If it's per facility on your association, that's more insurance, but there's always going to be an aggregate for the total amount of the policy. Well, why is this important? Because the total aggregate is all that that vendor has for all of its platforms. How many of you know how many pools each one of your vendors is involved with? Do they have 20 communities that each have 5 pools? So now we have 100 pools, which are in the risk category for the total amount of the liability. And in this instance here that we just looked at, we had a $2 million excess and a $5 million overall general aggregate. Right. So I have news for you. $6-8 million for a drowning case is not a lot of money. If you have 2 drowning cases in that vendor's configuration of pools that it's monitoring, the second claim is going to be short money for sure, and maybe even the first one. Yeah. So just a little bit more on per project versus aggregate, and this is what we've talked about. Let's make sure that you know how many pools they're guarding and how far this insurance has to spread. And don't be shy about asking. Well, why do you need to know that? Well, I want to know how many pools that $2 million has to take care of. And I want to know when your first claim comes in, because when your first claim comes in, I need to know that the insurance that the association has is now primary. Because even the association's insurance policy has less umbrella or excess than it had before. There's no doubt about it. The cost factors on these insurances for excess and umbrellas have gone through the roof. And so a lot of people that used to have 10 or $20 million have $5 million worth of excess now. And maybe that's enough if you have 1 pool. But what if you have 10 pools? And what if they have a whole bunch of things at the pool that create risk and your guard service is really not helping you? So I want all of this thrown into a blender as you figure it out.
To that point, Mark.
Yeah.
Would you recommend in the MSA having a reporting provision?
Oh, absolutely. Absolutely. We want to make sure that if they have a claim at one of their other facilities, that we become aware of it. Because that's when we know that there's a risk that the association's insurance becomes primary. And you might want to have a right of termination. You might not be able to get another company that quick, but you might want to at least try to get a right of termination if that's the case. All right. All of the insurances are important, okay? And having that provision in there that theirs is primary and non-contributory. And I've put some provisions in our contracts now that say that the association can't settle the pool vendor can't settle its claim without getting a release for the association. It's a use of some ink on paper, but unless the insurance company agrees to it, it's not going to be applicable. The law in Texas is pretty safe to say that the insurance company's liability stops when they run out of money and they can pay their money as they see fit. So this is something that potentially in the future we'll ask for some endorsements on. I don't know if it'll cost more money, but it puts them holding the bag and not being able to settle the pool vendor's claim unless and until they can get a full release. And you want to make sure they have all the insurances, okay? And so we include this list just so that you have it. Eric talked about the MSA. Absolutely critically important, not just for your pool vendors, but for everybody who the association does business with. And the most important provisions in addition to insurance is indemnity. Nobody understands indemnity. They think they know what it means, but you really want to make sure that the indemnity is written properly. There's legal requirements as to type sizes as to things which result in the insurance coming forward and paying. And we want to make sure that there's a duty to defend, a contractual requirement to indemnify with insurance. And we want to specifically state that they have the skill set to do things, that they have the people monitoring, that even if we have a 15-year-old lifeguard, someone's supervising the 15-year-old lifeguard. And what will happen if there's a default? So you want to look at your indemnity, and is your indemnity, as a result of default, terminate a contract? Or does it give you some rights to offset against funds? And then the ultimate question is, should you have a right to terminate, and should you terminate? I think if you terminated a lifeguarded pool and couldn't get a replacement in a community that has major facilities, the tar and feather and pitchforks would come back out.
Yep.
So you want to be careful to not do any of the things that are going to totally alienate you from a neighborhood. But these are very, very intense issues, and there are things that you have to consider with each contract, but never more so than with the pool contract, which has the greater risks of liability. Now, someone popped a question up that I saw across the screen dealing with the liabilities to the association as to a SAYOR pool. Well, if there's no requirement for a lifeguard, there's no requirement for a lifeguard, as long as everything else you're done right. So what would that mean? Well, do you have all your life safety equipment? Is it all functioning? Do you have a 911 phone? Do you have a shepherd's hook? Do you have a ring? Is someone periodically checking it? Are you making sure that the self-latching gates are self-latching? All of the things that need to occur. Are we getting the questions here, or do you?
I can read them.
Yeah, if you could, yeah.
I don't really understand what this first one kind of means, but let me put it to you this way. For with the SAYOR pool, can associations, if they have a lot of homeowners, have a fear their kids are going to drown, have committees of homeowners serve as the lifeguards?
That's a great question, and I think they should lifeguard their own children. They should not lifeguard anyone else's children, because as a committee, then the association is taking on the responsibility of being the lifeguard, and they should not do that.
Correct.
All right, we agree, so we should move on before we disagree.
Yes. So as a board, how do they address the fear from the homeowners if you're getting people say, you can't have SAYOR pools, you can't cut the cost of the lifeguard? What should boards then turn around?
I mean, it's really a community decision.
Yeah.
You know, the community elects the board to represent it. The board should represent the interests of the community. I think before switching from a guarded pool to a SAYOR pool, that town meetings, not an annual meeting, not a board member meeting, but just town meetings, and grab people together and say, look, we're spending X dollars on lifeguards, and we don't mind spending it, but we're not sure we're getting bang for our buck anymore. We want the pool. We want y'all's opinion. I mean, the other option is, if you're going to have a lifeguard and the pool contractor's not going to have any insurance, maybe you hire lifeguards as an employer. So I'm not a big fan of that because of the employment issues, but you really need to do it. Now, let me tell you, when you call the town meeting and the issue is we're going to save some money, two questions are going to come up. How much is my assessment going to go down? And the answer is probably none, okay, because you're short funding your reserves or something anyway. And the people that are going to be the loudest that say cut the funding are the ones that probably never use the pool, okay?
Yeah.
And a majority of the people in your communities never use the pool, so are they really the ones who should be talking about whether we switch to a SAYOR or not?
Correct.
Okay.
And the other issue to that point, Mark, is, you know, if you've been a guarded pool since the beginning of time, and then you all of a sudden make the decision, we're going to go SAYOR, and you don't have these types of discussions with the community, that's the tar, feather, and pitchforks are probably going to come out. So be cognizant of that.
There you go. All right, we got time for a couple more, Kyle.
Yes, sir. Can you please explain the difference between excess and umbrella coverage?
No, we'd have to have another day. Let it suffice to say that the thing that's important is that they're following forms. What I mean for following forms is that the excess or umbrella policy covers everything that the others did, and that there's not an additional level of retention, not another deductible that has to be met before that policy kicks in. So we want to make sure that it's a continuous flow. So if you have a $5 million excess on top of a $1 million per incident occurrence, we want to make sure that the second million kicks in right away.
All right, comment that's come back in regards to, people commenting on the use of pools. This person says their situation is the opposite. Non-swimmers are trying to keep the lifeguards and the swimmers want SAYOR to have more hours with the pool open.
Yeah. Yep, it's going to be the same problems in every community. It's a different slant on the same approach. I think you need to get the will of the entire community, and the non-swimmers want the lifeguards because they're fear of the liability. Once they understand that that particular pool is not required to have it, and we're willing to do what is necessary to show that we've maintained the pool properly, it doesn't really increase the liability. And the reason we used lifeguards mostly was to shift the liability.
All right, swim teams. Are there issues with conducting the meets on property, especially with having other teams, meaning non-residents, using the pools?
I mean, it's just people using the pool, and at a swim meet, have you ever heard of an incident? I've heard of slip and fall on the deck, but have you ever heard of an incident where someone had a drowning?
I've never heard of a drowning.
Yeah, I mean, there's so many people with eyes on the pool. I would think that that's probably the least liability. I'm not an expert on this, but I wouldn't think that that's problematic. The issue with bringing people in from the outside is a different issue, and that is your pool fully accessible? You have to be accessible to disabled if you open to the public, and bringing in a team from outside your community. And it's not just the pool, it's the restrooms and the adjoining facilities.
Parking lot.
So be careful.
Here's an interesting question. Workers' comp. If a lifeguard gets hurt, would the HOA's workers' comp policy cover a vendor?
All right, the workers' comp policy should be by the pool company. And that's one of the insurances that are required of the vendor, and you shouldn't allow them to come on site without it. The reason why an association carries workers' comp, even if it has no employees, is in the off chance it made a mistake and hired a vendor that didn't have comp, or their comp got canceled, and they're now claiming to be an employee. But if they're not our employee, our workers' comp would fight like heck to say that they were not an employee and they were employed by someone who was not a subscriber to the Workers' Comp Act.
And again, this is something that's addressed in the MSA.
Absolutely.
So that's has a contractual obligation to not only have workers' comp, but keep workers' comp.
All right, so someone just asked a question about ADA, and I think we probably need to tee up another seminar on the distinctions between ADA and fair housing and their application to associations. ADA is not applicable to most associations because it's the Americans with Disability Act, which applies to employment. Now, for your employees, you have ADA related issues. Employees, not management, third-party employees. But the association is responsible for fair housing compliance for equal access to those who are disabled under the act. And so those are distinctions, and that's kind of I could do it in 45 minutes. I don't know. Could you name that too in less, Eric? I really think we need about 45 minutes on that topic, and I think we put one of those together sometime this year.
We actually did one in January.
Well,
So
it's on January. It's available in our YouTube library.
Yes.
And if you need to know how to get a hold of it, contact Kyle.
Yes, please do. I don't see any other questions coming in, so we'll give it about a minute or so.
All right. Well, in the meantime, let me ask Eric some questions. How many calls do you get a month at this time of year regarding pool-related issues?
A bunch. A whole
And
bunch.
are people willing to do the master service agreement, or do they want you to look at the pool company's contract?
It's, I would say, less than 50-50.
Okay.
And I've tried to stress this to our clients, Mark, that because a lot of times what it boils down to is the boards don't want to spend the money to have a contract reviewed or to have MSA prepared. And, I hate to say this, but that's very penny wise, pound foolish,
Oh, absolutely.
in my opinion.
Absolutely.
Because if you do have an MSA that shifts the risk, has all the insurance requirements, and the vendor meets the insurance requirements, and then an incident does occur at the pool, Mark, for the relatively small amount of money to have that contract reviewed and have the MSA prepared versus a multi-million-dollar legal fees and judgment, whatever you might have. So it's extremely important, especially with a pool, because what if it's somebody's just changing light bulbs for the association? Yeah, probably don't need an MSA for that. But a pool is inherently dangerous because of the risks and the threat of somebody drowning or whatever else may occur. So if you get nothing else from this presentation, please talk to your boards about MSAs for your pool vendors.
Well, the reason you buy insurance is so you don't have to pay things out of pocket. The reason you hire a lawyer to draft a master service agreement is so that the insurance will actually pay as opposed to the association having to pay.
Right.
So you want to be careful. But let me tell you something. Just getting the contract prepared is only part of the barrel. Making sure that the vendor meets the requirements is another. I have personally done insurance audits for many associations, and I pull a contract and I say, wow, these are some good contracts. And I go, show me the COIs. Well, the COI doesn't match the contract. They had a piece of paper that said COI, stuck it in the folder, but it didn't match, so it was worthless. You spent a lot of money on a service agreement that didn't do it. Do you know there's a company that verifies that your insurance matches the contract? And they do this as a service.
I did not know that.
And it would be a really good service if they had responsibility if they were wrong. But they only use their best efforts to figure it out.
Yeah.
So really use somebody that has some kind of culpability if they screw up. Use the attorneys. That's what they're here for. And it doesn't take long to make sure that that certificate of insurance matches the requirements in the contract. All right. I believe we've answered as many questions as we can for today. We have a seminar coming up next month.
We have another one coming up next week.
And what's that on?
That's on collections.
Oh my gosh.
Collections for the rest of the month.
Collections. That's going to be really exciting. And Teddy and Noel are going to speak. Hey, if anyone shows up, ask them about Regulation F. They'll be excited to talk to you about it. And I'm going to leave that as a teaser. Eric, I've enjoyed today, Eric, and I'm hoping that y'all have a great rest of your day. Bye.
Bye, guys. Thanks for joining us.